We have some breaking news right now from the Supreme Court. My understanding is the decision on Fisher versus the U.S. has just dropped. This is the case involving that January 6th rioter who is charged with obstruction of an official proceeding, who is challenging that charge specifically. Carrie, is our Ryan Riley ready to go on this? Okay, Ryan, so fill us in to remind us of the details of this specific case, as I know our teams are reading in on the decision.
That's right. So the 6-3 decision is what we're looking at here. This involves obstruction of an official proceeding, which is a charge that has been used against a number of January 6 defendants. It was essentially used to, I think, pressure some defendants into a plea deal because this was something that gave them more criminal exposure. But I think the key thing to take away here is that a lot of the defendants are facing other felony charges. There's a narrower set of defendants who this is the only felony charge what they face. That's the spectrum of people we're ultimately going to be talking about being impacted in the January 6 case by this. So you're talking about in the neighborhood of 52 cases of individuals who that is the sole felony charge which they face, which could have an implication for them. Of that group, you're only talking about 27 individuals who actually are still in prison today. So you could see a situation where people are going to be potentially getting out of jail because they've already served over the amount of time that was the maximum amount of time they could have served for the misdemeanor, which is 1 year, but had not yet served the full felony charge. So this will have potentially practical implications on these individual cases, but it's not going to have necessarily the sweeping impact that I think some people necessarily feared about all these January 6 cases, even though it was used in hundreds of cases. In the majority of those cases, you're talking about individuals who had another felony, often a violent crime. A case that comes to mind for this that was recently decided involved four California men who were convicted of obstruction of official proceeding, and two of them had that only charge that was only for the obstruction. That was their only felony. They are also sentenced to a year for their misdemeanor charge. And I remember sitting in that courtroom. They were walked back. They were taken back after their sentence. And that sentence is basically going to be potentially shrunk down now to the top level of what they were sentenced to for the misdemeanor. I would also say in a lot of these January 6 cases that I've been seeing recently, judges have sort of prepared for this. They prepared for the Fisher ruling and have said explicitly in the record during sentencing hearings that they would have decided this sentence and posed the same sentence even if the Supreme Court ultimately overturned Fisher. So this is something that I think that prosecutors who have been handling these cases have been preparing for, as well as judges who have been sentencing cases, given they were sort of reading the tea leaves that we saw earlier during the Supreme Court's oral arguments. Anna.
All right. Legal analysts are back with us. Lisa, I know you're trying to dig into the decision. What can you tell us about what you've learned so far?
Well, Anna, this is an interesting split of the court. You have Justice Jackson joining a number of the conservatives in the majority in an opinion written by Chief Justice Roberts, and Justice Barrett in dissent. But the holding here really narrows the meaning of this statute that penalizes obstruction of an official proceeding. And that statute has two sections. One that pertains to obstructing an official proceeding by use of records or documents or objects or other things used in a proceeding. And then there is sort of what people would have described as a catch-all provision afterwards that says, or otherwise impedes the functioning of an official proceeding. And here, what the court is deciding is that that section that has the catch-all phrase, otherwise obstructs, influences, or impedes any official proceeding or attempts to do so, that must be construed in light of the first, more specific phrase. That means that anybody who's been charged with obstructing an official proceeding by, for example, physically blocking Congress from doing their job on January 6th, if they didn't, for example, block that official proceeding by use of a record, a document, an object, or an other thing used in the conduct of Congress's session that day, this charge can no longer stand. And when we think about how many cases are affected here, it's my understanding that nearly 250 people of the more than 1,400 cases that have been brought against participants in the January 6th event involve one of these charges. So Ryan is absolutely right that the number of people who are facing charges only on this count is very limited, maybe a few dozen. But the number of defendants who have been charged with Section 1512C of the U.S. Code, Title 18, numbers over 200 and almost 250. With respect to former President Trump, what does this mean? He has been charged with obstruction of an official proceeding and conspiracy to do so. But remember also, the allegations against him in the pending indictment cover things like the fake elector scheme, which one could describe as an attempt to obstruct Congress from doing its job by interposing false records. Will those charges then against him stand? I think that's a matter of interpretation. And should the indictment against him survive the presidential immunity challenge, yet another issue for Judge Tanya Chutkan and other courts perhaps to have to wade through as that litigation progresses, Anna.
So let's peel the onion back a little bit, layer by layer here. Lisa, you were comprehensive in laying out a little bit what this case is telling us and what it could mean for not only this case, but many others, hundreds of others potentially, including Donald Trump's. And let me just remind everybody about Fisher and what his actions are alleged to have happened on January 6th. He was arrested and charged with assaulting police officers, among other charges, and then he was charged with his obstruction of an official proceeding for the actions at the Capitol. Prosecutors say he urged rioters to charge in there. He himself is a former police officer and tried to appeal to police officers during all of this, but he was part of this mob, prosecutors say, that pushed the police, hence why he is charged with assaulting a police officer. So Neil, just what does this mean for, one, his case, and how do you see this impacting the other cases that have this specific charge, including Donald Trump's?
So, Anna, this is a long and technical decision, and from my first glances at it, and we've only had it for a couple of minutes, I'm not sure it's going to have any sort of dramatic impact. And the reason is this. This is a statute that was passed after Enron and the accounting issues called Sarbanes-Oxley as part of that legislation. And the way that, certainly everyone agrees the kind of, thing that they were most concerned about was destruction of destruction of documents and evidence that would be used in a trial. Now, what the court today says is, well, it actually has to focus on destroying those documents in some way or undermining their use. And this is where I think Justice Ketanji Brown Jackson's concurrence is so important. She agreed with the majority and said, look, this statute could be overly broadly read by the Justice Department, but even with respect to Joseph Fisher himself, she says, he still could be charged because it's an official proceeding that plainly used certain records, documents, or objects, including the documents relating to electoral votes themselves. That's a quote from her opinion. What that means in practice is that even Fisher isn't necessarily going to get any relief from this decision, let alone any of the other hundreds of defendants, and certainly, I think, not Donald Trump, because this is a very narrow decision that doesn't say, Trump or Fisher or anyone else is off the hook.
Hey there, MSNBC fans. I'm Luke Russert, and be sure to join me, Rachel Maddow, Jen Psaki, Lawrence O'Donnell, Steve Kornacki, Joy Reid, and many more September 7th in Brooklyn, MSNBC Live Democracy 2024. Click on the link for ticket information. We will see you there.